So today, this afternoon, I'm going to be talking about institutional violence. I call it institutional violence because I'm dealing with two different areas of law, of my law practice. So I represent students and administrators in educational institutions, and and I also represent inmates and correctional staff in jails. So that's why I named it institutional law, because the the sort of, you see a cross pollination. So the sort of situation you see happening in schools sometimes, you see it also happening in prison institutions, and basically all students have a right to education, and that's in our Education Act. And all students include students who have mental disabilities, and sometimes whose mental challenges pose a risk of injury to others. So we have students who suffer from various exceptionalities, and so sometimes they don't appreciate the nature and the quality of their behavior, but they're entitled to an education too. Now, this is where you have the sort of competing rights. At the same time, school staff, including teachers, educational assistants, have the right to a safe workplace. So they have the right to work in a workplace that is safe, respectful, and nonviolent. And you can make the same argument as well for correctional staff who um, have to manage violent inmates. The question then becomes, how should school boards balance these rights when they're in conflict? What are the duties and obligations under the Education Act, the Human Rights Code, and the Occupational Health and Safety Act? Right? So those questions go to the heart of competing rights. The student have the right to an education, and the teachers and administrators have the right to work in a safe workplace. And so one has to look at the statutory and policy framework for school board violence, and how school boards go about managing high risk behaviors. And certainly, I do a lot of cases involving Toronto District School Board, for example, where I represent students who are accused of bullying, and I also represent students who are victims of bullying. And so sometimes we look at tools such as suspensions, expulsions, exclusions. And one of the cases that I was involved in, one of the leading cases in exclusion, is a case called KB and TM versus Toronto District School Board. That's a case that I argued in 2007, I believe. The decision is a 2008 decision from the Divisional Court. right? So that case dealt with exploring the ways that a school board can manage conflicts, can manage fights, can manage bullying in its environment. But there's something else. Can a teacher or an administrator refuse unsafe work? What if a parent or a student or a group of students is threatening to a teacher or an administrator? Can they refuse to work in light of safety concerns? And there's also another issue is balancing students' privacy with a duty to provide information to workers under Section 32.0.5 of the Occupational Health and Safety Act. So, the Occupational Health and Safety Act, Section 32, comes into play if a violent student from one school is transferred to another school. And so the Ontario student record follows that student to the new school, but in the Ontario student record, there's no discussion of the student's history of violence. And as well, the student's violent past was not discussed with teachers and other people who need to know, so that the student has a violent episode and the student has a significant meltdown and hurt a teacher or hurt another student, and there was information in the file with respect to the student's conduct and the student's predilection to violence, but that information was not transmitted to those who need to know, such as their teachers or their educational assistant or parents, in some cases, whose kids had to interact with this violent kid and was subject to an assault or some other behavior from that student that raises safety concerns. So this is an issue in the educational environment that I have to deal with. An issue as well as do a teacher qualify for WSIB payments if the teacher encounters an issue with the student and goes off on leave because of post-traumatic stress disorder or any other forms of disorder, similar to correctional officers who engage in situations where they witness serious acts of violence, including deaths and serious injuries. What is the scope of workplace injury coverage for those employees? Can a human rights claim be asserted either by the violent person or by persons who have been subjected to violence by that person? We have Bill 136 in Ontario, which is preventing workplace violence. So you have all these things, including the Occupational Health and Safety Act, that one has to consider. But I am mulling over these issues because, interestingly enough, it's January 9th of 2017, and within the last few days, within the last 48 hours really, I've been inundated with calls from parents of children from kindergarten to grade 12 in schools who have issues dealing with either being bullied or being accused of bullying. And so these are issues that I have to deal with at the moment. So I thought I'd news loudly about it, because certainly the issue of violence in schools, the issue of violence in the workplace the issue of violence in the provision of services are all issues that are captured within that specific situation of schools, because obviously the school is a service provider to kids who are being educated, but it's also a workplace for those people who are employed therein. So it certainly raises some interesting competing issues. So obviously, teachers have a certain role, and administrators particularly when dealing with these violent encounters, because they also have their code of conduct under the College of Teachers Act. Plus, they also have reporting requirements under the Child and Services Review Act. So there's so much legislation that governs violence in schools that it's quite a jumble to sort of get oneself through it. And so sometimes in these cases where such situation occurs, timely legal advice is important. Sometimes people feel that they should be their own lawyer or sort of muddle their way through these issues with school boards, but there's nothing beats timely legal advice when dealing with issues involving school boards, because the truth is, if things don't go in your favor and you complain afterwards, most times it would not go in your favor. It would not. Well, let me put it differently. It would take a Herculean effort to undo something, a decision that has been made in the first instance, when you could have spent far less time and far less resources if in hiring a lawyer to get those issues dealt with. So whether a student is being bullied or is a bully, I think the parents should be well advised to seek legal advice on your options if the school board initiates a process to deal with the allegations, because the consequences that flow could be significant for the student, and the cost to undo it can be prohibitive if you didn't have access to timely legal assistance. And